the bond violation report, I would like to take them in that order. As for the evidentiary hearing on April 5, the court made a finding of probable cause in this matter and denied the defense motion to suppress, invited some research and possible briefing on whether the law required something more specific as to the intoxicating, impairing substance than we appear to have in this case. I have since done reading of case law. I have polled defense colleagues, especially Section 625 defense practitioners. And the result of that research is I have not turned up authority that would preclude the court from having made the finding that it made, or that would compel the court to make a different decision in this matter. You may have gathered that from my not having submitted any briefing in advance of today. Accordingly, we are resolved to let the court's finding and decision stand as it was made.
All right, very good. Okay. Then where shall we proceed from here? Because, well, we've got the bond violation that we have to deal with. I'm presuming there's no objection to the court's ruling standing by the people.
Of course not.
Now the bond.
Your Honor, if you recall, on February 22nd, this court gave the defendant a shot, and that's exactly what the court said. You said that he needed to go into an outpatient treatment, and that you would issue a bench warrant with no bond if he misses or there's a positive test. I had asked for a remand on the 15th and on the 22nd of February. And you stated if he had tested positive again, then bond would be revoked and he would be remanded. So we had our hearing on April 5th, and on April 10th, the defendant had negative but abnormal creatinine. And then on the 11th, the defendant tested positive for cocaine, and then he missed tests on the 13th, 17th, 18th, 19th, 25th, 26th, 27th, and May 2nd. So I would ask for this defendant to have to report to Washtenaw County Jail by 6 p.m. Honestly, Mr. Davis might look intoxicated at this moment. So I have very serious concerns for the defendant, and obviously all of the missed tests, and the last one before the missed test was that he was positive for cocaine. This isn't operating with the presence of a controlled substance cocaine case. So I have serious concerns for himself and for the community.
Mr. Davis.
Thank you. I don't have much to disagree with Ms. Kirby's recitation of the history of bond conditions and compliance with those. We have received the latest bond violation report from Community Corrections. I have shared it with Mr. Davis, and I understand from my discussion with him, I have explained to him his rights as to process on a bond violation. I understand from those discussions that he is resolved to acknowledge, admit the violations, and accept the court's sanction.
Very good. Is that correct, Mr. Davis, that you don't wish to have a hearing and you admit to the violations?
That is correct, sir.
All right. Anything you want to say to me?
Not exactly, other than
Mr. Davis, when was the last time you used?
last week.
You haven't used anything this week?
No, I'm sober right now.
Go ahead. What else did you want to tell me?
I have something when there's a turn, when there's a chance, Judge.
Go ahead, Mr. Davis.
Thank you. Also from discussion with Mr. Davis, I wanted to make note that the problem on our side is one of dependence and probably addiction, deeper going, longer lasting than we recognize. And it's not one of disrespect for the court or incivility, but it's the format that I described, and we are looking to address that as the process allows.
Anything else, Mr. Davis?
No, Your Honor.
All right. With these violations, and it was clear back in February what I had indicated, and Ms. Kirby correctly points out that on the 10th, 5 days after the last hearing that we were here, it was negative, but you had an abnormal creatinine, which this court considers a positive test in any event, because it typically will mean that you're attempting to try to mask any substance. You go in the next day, the masking is off, and you test positive for cocaine. And then ever since then, you've missed tests. It's this court's order that your bond is hereby ordered revoked. Defendant is to surrender to the Washtenaw County Jail. Quite frankly, in looking at you, sir, right now, I don't believe you that you haven't used since last week. I believe that you've used today, and therefore I'm not giving you till 6 p.m. You're to report to the Washtenaw County Jail by 1 p.m. You've got about an hour and 50 minutes, and you need to be at the jail. If not, I'm going to issue a bench warrant for your arrest. Actually, quite frankly, if necessary, I will be sending sheriff deputies out to get you. You need to get to the Washtenaw County Jail. I'll set a pretrial. Well, where were we in this? I'll set a pretrial hearing next week.
Yes, the 15th.
For May 15th. Okay.
1 p.m.
At
Or
what?
10 a.m.
At 10 a.m. And, sir, I will tell you, you can take your chances on trying to see whether or not you should turn yourself in by 1. One thing that you can bet with me, we're going to get you. So I'd suggest that you be there, because if you go in the hard way, I don't know when necessarily I'm going to ever let you out, treatment or not. Am I understood?
Understood, Your Honor.
Anything further?
No, Your Honor.
No, Your Honor. Thank you.
Thank you.
Ms. Kirby, I'll see to be in touch.
Until 1 p.m.
All right.
1, 2, 3, 6, 7, 8, 9.
Okay. Court does call the case, People versus Susanna Williams.
Maria Ursinski on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Williams. Could you unmute and state your name for the record, ma'am?
Yes, Susanna Amanda Marie Williams.
Thank you. Your Honor, in this matter, we did adjourn in order to receive some video from inside the store. We were provided with a disc. At this point, we're not able to view what is on the disc, so I would need an adjournment so that I can coordinate with the prosecutor to see if we can get a working copy.
Question.
Okay.
I mean, we've adjourned it like 3 times, and this is 93-day misdemeanor. I've already served 90 days in jail, and I was just, we've adjourned it two times, and they haven't provided the video. I had a letter I wanted to read to you, and if we could get it.
Ma'am, Ms. Williams,
today.
so you're being held on other matters. So because of that, and because of the fact that you wanted to see the video from in the store, I think it's in our best interest to adjourn so that we can receive that video, given that you're already going to be in custody. And this case itself is not going to extend your time in jail.
Right. I completed the Don Barnes in jail program. I thought I would be released after that. That's
You
why I
can
was
be considered for release.
Okay.
Okay. So
Can I read this letter?
I would advise you not to at this point. I'll come meet with you and see if we can clear things up. Okay. We'll see that if if you're able to be released on your other cases, I'll make sure to coordinate the bond in this matter for you. Okay.
Right.
Ma'am,
Yes.
was there something that you wanted to tell the court? I just want to let you know that you haven't been held. You may think you may have been in jail more than 90 days. You haven't been held on this case more than 90 days.
Okay.
Okay, so I need you to know that. Okay, so you don't have that much credit on this case.
Okay, I didn't commit the crime, but I was under the impression that after Dawn Farms, I would be considered for release, which I completed that yesterday, and I just had a letter to read to you.
Okay, hold on. I got you. But let me just ask you this. You got other things holding you, right?
No, just this case, the other one from which you said I could be released after Dawn Farm, just for you.
And you are being held on that one presently. The
Yes,
documentation needs to be provided to the judge for consideration if he'll release you on that matter. So he has not made a determination in that case yet.
So then do I have a bond on this one if he does release me?
That's what I said. If he releases you on that other matter, I'll make sure that this case is updated appropriately. Okay. But since right now you're still being held on that matter, we don't want to change anything in this case.
I provided it yesterday, but okay.
And hopefully you'll hear back soon.
So then I can't read this to the judge then?
Given that I don't know what it is that you're trying to state, I think it's safe not to.
You didn't come to see me in the 2 weeks, like other people's lawyers come and see them 4 or 5 times.
Well, we're still waiting for video.
And then I'll have been here over 93 days, so why don't I just squash it out and be
You,
done with it?
ma'am, no, you won't. You will not be on this case. You have not been held over 93 days.
Okay, well, I didn't, okay.
Maybe what you ought to do is listen to your attorneys. She's trying to tell you that there's another matter. Once the Dawn Farm comes in, we'll take a look at that. If you're released on that one, she's going to coordinate it so that this one doesn't hold you.
Okay, thank you.
So you need to let them do their work.
All right, I appreciate that.
All right. Thank you.
Thank you. Have a good day.